Every child knows the phrase finders keepers, but does it apply to chimney sweepers? Can a poor boy from the streets of 18th-century London overcome the scheming of a rich, well-connected silversmith? It might sound like a Dickens novel, but it's actually the case of Armory versus Delamirie, one of the great cases in English property law. Armory was a chimney sweeper's apprentice in London in the early 1700s. It was a difficult life. Chimney sweepers took on child apprentices, in part because the boys were small enough to wedge themselves up the chimneys to clean them from the inside. In an age before workplace safety regulations, the children faced hazards, including respiratory illness, burns, rare forms of cancer, and death from suffocation in the crushing confines of chimney flues. One day in 1722, Armory found a piece of jewelry. Exactly where and how he found it are lost to history, but to the chimney sweeper's apprentice, it must have seemed like winning the lottery. Armory took the jewelry to a silversmith's workshop, presumably intending to sell his find and cash in on his good fortune. The silversmith was Paul Delamirie, a renowned craftsman with clients among the nobility of England. There are indications that Delamirie was a shrewd operator. A few years earlier, he had been fined for failing to hallmark his work. This meant that he failed to stamp the work as required by law to indicate the origins of the piece and guarantee the purity of the metal. He'd also been accused of claiming authorship of other silversmiths' work. A few years after the Armory case, he would be associated with a criminal investigation into the illegal export of silver. On this day, however, Armory entered Delamarie's shop and handed the jewelry to Delamarie's apprentice. The apprentice removed the stones from their settings, ostensibly to weigh them. The apprentice told Delamirie that the stones were worth 3 halfpence, about $2 in today's money. Delamirie then offered the money to Armory. Armory quite sensibly refused and demanded the jewelry back. The apprentice gave Armory the jewelry, but where the gemstones had once been, there were empty sockets. Evidently, the apprentice, or Delamirie himself, had decided to keep the jewels, regardless of Armory's consent. Armory left without the jewels and sued Delamirie for trover. Trover was a common law cause of action for wrongfully appropriating someone's property, much like the modern tort of conversion. In everyday terms, Armory claimed that the jewels belonged to him and that Delamirie had wrongfully taken them. At trial, Delamirie argued that Armory had no rights to the jewels because the boy had merely found them by chance and wasn't their true owner. In other words, Delamirie couldn't be liable for violating Armory's property rights because Armory had no property rights to begin with. The trial court disagreed with Delamirie and found for Armory. Because Delamirie never produced the jewels, the court awarded Armory money damages instead. Delamirie appealed to the Court of the King's Bench.